Hello everyone, welcome to Digital Research Academy. Today we're going to talk about CLAT PG 2019 incorrect question and answer. 2 days back we have sent email to students regarding whatever their incorrect options. Kindly send it to us, and they have sent a lot of confusion regarding the question and answers, and we have compiled them, and in this video we are going to talk about them. Okay, so what we are going to talk about in this video is just the compilation, what the students have conveyed to us, nothing we have incorporated in it. Okay, if you want us to make a separate video regarding this, we are going to make it tomorrow, but this particular question and answer video is going to give you what are the question, there are confusions, there are problems, and you can rectify it by your own. If you face any problem, kindly comment below. Okay, so let's delve into this particular video. The first question that the students have raised concern regarding this question: in Rowlands versus Fletcher, Justice Blackburn used the term. Basically, the CLAT answer was given C, strict and absolute liability, but the students were saying, some portion was saying question number A, and some answer A, some portion they are saying answer is D. So basically what their reasoning is that some of them are saying that Justice Blackburn has used the term first time strict liability, and after that in MC Mehta case, Indian MC Mehta case, the absolute liability came into the picture, the concept of absolute liability that I am talking about. And why they are saying the some portion, why they are saying none of the above, it's because they are saying Justice Blackburn hasn't used any term. So that both are the logic that were given. Okay, so search by yourself what is the correct answer, and if you can't get the right answer, we are going to make the video tomorrow if you want us to make the video. Now let's talk about the second question. Second question is voluntary non-fit injuria is a general defense, particular defense, not a defense, defense in tort of law. Now here also the CLAT answer given C, not a defense. The students are saying, and there is also two branches of students. Some students are saying it's general defense, some students are saying defense in tort of law. Now kindly go and research what would be the correct answer. Okay, if you didn't get it, let us know. Now let's talk about the question number 3. Now question number 3 is defaming someone by words or by gesture is called in tort as libel, slander, nuisance, none. Now the CLAT answer was given A, but the answer would be B, slander. It's called slander. Now let's talk about the question number 4. The question number 4 that was raised concern is regarding right to vote in elections in India. Is a fundamental right, constitutional right, statutory right, or customary right? Basically, the CLAT answer was given B, that is constitutional right. But in the case of PUCL versus the Union of India, that is basically known as Nota case, in that particular case, it's given the right to vote is a statutory right, not a constitutional right or fundamental right. So you can refer that case and substantiate your answer. Now let's talk about the next question. The next question is ordinance making power. So it's a legislative power, but it's given as an executive power as an answer. So correct answer would be B, a legislative power. Now this question is regarding the patent. Which of the following statement is right? An invention must not possess the utility for the grant of patent, and no valid patent can be granted for an inventions devoid of utility. An invention must possess the utility for the grant of patent, and no valid patent can be granted for an invention devoid of utility. An invention must possess utility for the grant of patent, and valid patent can be granted for an invention devoid of utility. And the other option is D. The CLAT answer was given D, but the correct answer, the students were saying, as they have raised, that an invention must possess utility because it is the one of the main ingredients for granting a patent. So no valid patent can be granted for an invention devoid of utility. That should be the correct answer according to the students. Now let's talk about the question number 7. Now question number 7 is quite, students are in doubt. They raise the concern but they don't know the real answer, and they haven't given any reasons for that, why they are thinking. According to John Austin, the relationship between the sovereign and political independent society is symmetrical, asymmetrical, elliptical, and relative. The CLAT answer was given C, but the students were saying they were a bit in doubt regarding the CLAT answer C. So you can definitely check this whether it's correct or not, and the correct answer they are saying is B, asymmetrical. Now let's talk about the next question. Next question is John Rawls' concept of justice. Now regarding John Rawls' concept of justice, the theory that John Rawls is given is known as political philosophy. Okay, so the students are a bit confused regarding whether the answer should be B or D. The CLAT answer is given is B, political concept, and students were raising concern regarding whether it should be political concept and also philosophical concept. So both answer can be right. So you can also research on this particular answer. Now let's talk about this particular question. Question number 9. A applied for allotment of 100 shares in company B. A letter of allotment addressed to A was posted in due time, but it never reached A. The posting of letter allotment completes the contract, does not complete the contract, makes the contract voidable, makes the contract void. Now the student who have said regarding this, the CLAT answer is given A, but students are saying K. The correct answer should be B. It does not complete the answer, and regarding that they have given one case like Lalman Sukla versus Gauri Datta. So you can check this case. In this case basically it has said that if it is not reached to the concerned person, then the contract cannot be completed. So kindly go and check this case and substantiate your answer. Now let's talk about the question number 10. Now question number 10 is basically a taught question. What defense could be used when an injury is caused to a person due to unforeseen or unexpected events in spite of reasonable care taken by him? Now CLAT answer is given A. The students are saying that it should be both A and C, inevitable accident and act of God. You can research on it, substantiate your answer. Now let's talk about the question number 11. The question number 11 is basically following committee cannot hear the individual complaints of human rights violation. A. Committee that monitors ICCPR, the committee that monitors human rights bodies, committee on the elimination of racial discrimination, committee on torture. So CLAT answer was given B. According to the students, the answer should be A. So kindly check this also. Now let's talk about the question number. Now question number 13 is basically regarding jurisprudence. For Roscoe Pound, jural postulates are to be covered in the law itself, outside the law, in the juristic thought, in all of the above. The CLAT answer was given A. The correct answer, as the students were saying, according to research, it should be B. So kindly check it out, substantiate your answer. Now let's talk about the next question, that is, Jus Gentium is a body of international statute, decisions of ICJ, international conventions and international customs. So students were raising regarding that Jus Gentium is a Roman law term, which means the law applicable to the non-Romans, and can't figure out the correct answer from the options. So that is a doubt students are having regarding this. So you can definitely check it out by yourself, what would be the correct answer, and then you can substantiate if there is any problem. Now let's talk about the question number 15. Now question number 15 is regarding the doctrine of severability was extended by the Supreme Court to constitutional amendments. There are 4 cases that were given. CLAT answer was given D, that is Kyoto Holohorn versus Judge Chilu. But the students, they raised this, that they have the doubt regarding this answer also. So these are the 15 questions that students have some kind of confusion or concern or problem, or the answers are correct, incorrect. So you check these answers. If you don't substantiate, we are going to, if you want us to make another video with the reasons, substance or the backing of the answer, why particular should be the correct answer and why it's not the correct answer, regarding that we are going to make that video also tomorrow, if you want us to make that video. So basically the purpose of this video was to amalgamate all the questions which students have the concern, and if any other questions that you feel that your questions hasn't been addressed here, then kindly mention below in the comment box, so that the other students can verify it, they can review it, and if you know any answers from these questions, kindly comment below, so that the other students who have the concerns regarding this particular questions, they can know the answer, and you can also verify it by yourself. So that will help regarding the questions. And if you like the video, give it a thumbs up, and don't forget to subscribe our channel to stay updated regarding CLAT, LLM, UGC, NET, SET and Judiciary. Until next time, thank you. See you soon.